House version is in the Public Health and Welfare Senate Committee right now, and we're just keeping another vehicle alive by sending it to the floor. Section 1 of the bill amends 41-29-113, which is Schedule 1. It adds 20 fentanyl-related substances and several other controlled substances. It's in the long title. Section 2 is 115, which is Schedule 2, and it adds a substance, and I can't pronounce it, alicidirin, has a currently accepted medical use, but has a high potential for abuse. Section 3 is 119, and that's Schedule 3 as well, and it adds several substances there in the long title. And then last is to include 2 substances on Schedule 5 and Schedule 4, cinnamomate and lasmiditan, and this was reported out of drug policy this morning.
All right, any questions about this one? If not, for a motion, you heard the motion, all in favor say aye. Any opposed, nay. The ayes have it. All right, Senate Bill 2261. It's not printed on your agenda, but you should have a copy of Senate Bill 2261. This is Senator Hill's bill, and we're going to recognize her to explain it for us.
Thank you, Mr. Chairman. This language, the pertinent language in this bill, this is basically just adding a section for youth court into the Mississippi Dog and Cat Protection Act. And actually, my youth court judge, in consultation with some other youth court judges, actually came up with this language. And she said that we're having more and more kids that are abusing animals. This one's named after Buddy, which is the dog up in Tate County that was set on fire. And Mississippi State has been nursing it back to health. And y'all know youth court records are sealed, but apparently this child did not get any type of help that he needed. And allegedly there are 2 deaths that coalesce with this setting this dog on fire. And so there's the Sheriff Lance up there and some of the other folks from that area in that case were very vocal in the media about wanting something to address youth adjudicated delinquent that were under the age of prosecution that were abusing animals to the point where they would be winding up in youth court. So what she suggested that we do is any child that's adjudicated delinquent receive a psychiatric evaluation and counseling or treatment for a length of time as prescribed by the youth court. The cost of any evaluation, counseling, and treatment shall be paid by the parent's guardian or by the state if the offender is awarded the state upon order of the court up to a maximum that is no more than the jurisdictional limit of the sentencing court. And the youth court shall hold the offender's parent or guardian in contempt if the parent or guardian willfully does not follow the recommended treatment for the offender. And she feels like it's got to have teeth in it, or it's not going to help the child at that point. And it's either do something when they're, in this situation, or to try to stop a life of being in and out of the system, or harming a human, because these kids are putting they're putting cats in the microwave. I mean, it's unbelievable. And she said it's escalating. The cases that she's seeing are escalating. So that's what the bill does. It's nothing to do with any other animals besides dogs and cats and adjudicated delinquents.
All right, questions, Senator Simmons.
Yeah, thank you, Mr. Chairman. I guess my question again is about placement. Title 97 deals with crimes. Youth court is a different title. And so we are amending Title 974116. I guess starting in lines 102 to 112, and we putting youth court language in a criminal statute under Title 97, right? Is that what we're doing?
Yes.
Okay. All right, another question I have. Are we telling our youth court judges in this statute what they already have the power to do? They have the power to order evaluations. They have the power to hold parents in contempt when they fail to comply with the youth court judge's orders, any order.
I'll answer this, and we are, because of some of these cases that have escalated into the actual killing of other humans, some of these animal abuse cases, and the judge feels like and I've consulted quite a number of youth court judges, they feel like that it is such to a serious level that it needs to be codified, that if they're adjudicated delinquent for the things that they're seeing right now, that they need a mandatory evaluation and counseling.
So the way this works, Mr. Chairman, once you go through the adjudicatory phase, then you get the disposition. Disposition in adult court is like sentencing. And so I guess at disposition, the youth court, youth court judge, youth court prosecutor, the guardian ad litem, all of those role players in the youth court system will determine what is in the best interest of the child. And
there may be something other than this that they also put in the sentencing. But this treatment and evaluation is something they felt like should be mandatory.
So is it a youth court judge that's not ordering an evaluation of a minor or a youth when they think an evaluation is the reason for the child behaving the way they behave?
I don't know what some of these other ones are doing, but apparently they're not helping the child as they should be helped, because after they've been in court for these type things, then they've gone on and committed other more serious crimes in a short period of time.
Thank you for yielding my question. Thank you, Mr. Chairman.
And those crimes do include murder of a human in some of those cases. And I can't elaborate because we don't have youth court records, but from what the community has told me, is it's so serious with these kids that they fear that if they don't get some type of psychiatric evaluation, then they're going to be facing what this kid that burned Buddy's facing, and he's fixing to be charged as an adult.
And I'm told that this is the particular code where if you're adjudicated delinquent, this is the code section that you're adjudicated delinquent under. So that's the reason it was placed where it was to your first question. You want to speak to that? Okay. Senator Turner Ford.
Thank you, Mr. Chairman. Am I clear that this, if this bill passes, every youth court judge that issues an order adjudicating a child as a delinquent must order a psychological evaluation? Or does this relate some sort of way to animal cruelty?
Only in regard to this section that it's in. And that's something that I asked already. And they said it's only in this section.
Say this section, I don't know.
Only in this chapter.
Line 60 and 61 says, in addition to such fine or imprisonment which may be imposed, and then you find paragraph C underneath.
So this is only for animal cruelty.
Yes.
That's correct. Yeah, it's the law that was passed in the last, I guess, 5 years.
Yes.
Yes. I knew that was the intent. I just wanted to make sure that's
Yeah.
what the statute says. All right. Other questions? Senator Simmons?
Yes, Mr. Chairman. I guess, so if this section deals with animal cruelty, there are other instances or other crimes that a minor commits that I would say will require, or a youth court judge will order a psych evaluation. It could be a minor actually committing a sexual act against his or her sibling. So are we going to go to the crime that deals with sexual battery and then put language in there saying we're going to order a psych evaluation in that title? Are we going to go to another crime title that deals with assault and say anytime a child assaults his or her parent, and then put language in there that says that the youth court judge now shall issue a psych evaluation? I guess I understand the spirit of what Senator Hill is doing, Mr. Chairman. I guess I'm just a little concerned. So I have a motion to appropriate time.
Okay. Any other questions? Senator Sparks?
Just very briefly, I understand the intent of this is that we have seen a direct connection with the abuse of animals by small children to matriculate up to abuse and injury against humans, other humans. And is that the intent of having the intervention at that point?
Yes,
Thank you.
that's the intent. That's absolutely the intent. And this case with this dog that was burned in Mississippi State, nursed back to health, the other crimes that that child committed or allegedly committed is what really brought this to light amongst law enforcement, youth court judges, and they kind of all seem to gravitate to this point right here. And I'm not a lawyer. I asked to have this drafted, and this is where it wound up. And they felt like that, sending them to Oakley wasn't the best thing, that the best thing that we could do to try to help these kids was try to get them some medical help, some psychiatric evaluation and treatment.
Other questions? If not, all right, we'll go with Senator Simmons. What states your motion?
Mr. Chairman, my motion would be to table. I move the table.
Okay, you're
And I'd like to
recognized
speak to that motion.
to speak to the motion, and then we'll, of course, allow Senator Hill to respond to that motion. Okay. Senator Simmons, you're recognized.
Thank you, Mr. Chairman, members of the committee. Title 9741-16 is not a youth court statute. It clearly is the Mississippi Dog and Cat Pet Protection Law of 2011. So it is a crime. And my concern is, even though I want to achieve what Senator Hill wants to achieve, I just think we should not be putting language in a crimes title regarding youth court. This is not dealing with adjudication. It's not dealing with disposition. We are putting youth court language in a crime title, 9741-16. Also, the reason for my motion is that our youth court judges are in a better situation than any of us, along with those other individuals in the youth court system, the youth court prosecutor, the guardian ad litem, the youth court public defender, to make determinations on when children shall be ordered to psychiatric evaluation and treatment. And so I think we should not be telling youth court judges what to do. I feel really, really sorry about what happened regarding Buddy, and certainly don't want our youth not to be properly rehabilitated to the point that they start going to circuit court. That's not the goal of what I'm asking for. I'm asking if we'll just actually lay this on the table and just look at a way to achieve the goal that Senator Hill wants to achieve, but not do it this way. Thank you.
Okay, you've heard the motion by the author. Of course, this motion would be a killing motion, but since this is deadline day, we would be coming back to resurrect that. You understand that, Senator Simmons?
I understand.
Okay. All right, Senator Wiggins?
Thank you, Mr. Chairman. I'm speaking against the motion for the reason that the chairman mentioned, number two, because since we talk about personal issues that are related to this, I spent a year as a youth court prosecutor, and I remember one case where the child put a cat, I think it was a cat, in a microwave and killed the cat. That kid then went on to the adult system. We have to do something. And to Senator Hill's point, Oakley honestly is probably going by the wayside, which may be the right thing to do, considering we were in appropriations in the subcommittee, and I asked a question, and this state is spending $17 million on 35 kids in Oakley. Now, 35 kids is costing us $17 million. We need to find better ways to address this. Then to Senator Simmons' point, I do know what he's talking about, because there is a separate youth court code section. And I do think that if that is a concern, then we can simply make an amendment that would conform it to that. But to kill this bill at this stage is not good by our children, and not good by what Senator Hill's trying to do. And I would ask that we vote against the motion.
Senator Hill, I recognize you.
I agree. This is what we have right now. Attorneys gave this to me. If it's not in the proper code section, like many other things that we flip back and forth that aren't in the proper code section, this still accomplishes the purpose that we want, and we want these kids to get some help. So I would urge you to vote against the killing motion on this bill.
All right, we'll return to Senator Simmons to speak, to close on his motion.
and again, I want children to get the help that they need. And I believe our youth court system is in a position to provide them the help that they need, Um, and so because I do this, I'm really concerned about youth court language being in 97-41-16.
Okay, you've heard the motion. All in favor of Senator Simmons' motion to lay the bill on the table, say aye. Any opposed, nay?
Nay.
Nays have it. All right, Senator Turner Ford.
Question, Mr. Chairman, could we not, I don't know, draft some sort of amendment or fashion this language to actually fall under the youth court law instead of,
Absolutely.
and it
Let's get
could
someone to
be,
make that amendment.
well, that would be my amendment, that it, to the extent possible, that we insert a sentence or two in the disposition portion of the youth court law that says a finding of a delinquent child for animal cruelty shall result in a psychological evaluation.
I think that's an amendment that's well taken that Senator Simmons had spoken to earlier. So any questions about Senator Turner Ford's amendment? Senator Simmons?
I support that amendment 300%, Mr. Chair.
Okay, great.
Question on the amendment.
You're recognized.
Your amendment is simply, let me put it this way, your amendment is to make that an addition to the bill, not in lieu of what's in the bill, the language in the bill.
I think the code section has been brought forward for disposition under youth court law. I assume that's what that section is.
No,
And what is it?
the youth court section is 47-7 something or other.
I could put this as a separate section in the disposition
Sorry,
area, but there wasn't a good place to put it in the youth court. That's why I put it here.
All right, back to Senator Turner Ford.
I just think it would be more appropriate if in the disposition language under the youth court law, if there is a provision that requires the youth court judge to conduct or to order a psychological evaluation in the event of a finding of a delinquent child under animal cruelty.
This specific code section, you're right. Yes. Okay, I think we understand. Senator Hill.
As long as it accomplishes the same language,
I would use that same language.
and it is referenced as Buddy's law, if Senator Wiggins is not in objection to it, what is your?
I am, since I'm being asked a question, I'm not in objection to it. However, I do think as bill is written, it needs to stay where it is and
Just
simply
reference it in that section
reference
as
in
well.
the youth court section. And that could be cured, and maybe I'm making an amendment to the amendment, which is in basically line 102, if the offender is a minor as defined by the youth court, it shall apply under the youth court statute.
And then bring the youth court statute in as well
Because,
to reference it.
yes,
The
But-
reason I put this language here was because it was I may be wrong on this, but it was my assumption that the child would be adjudicated delinquent under this section in youth court.
They
well,
would
that's
be.
right,
They would
because the definition under
I've
the
never
youth
practiced
court,
in
I
that
know,
area.
but the definition under the youth court act is if a juvenile commits a crime that would be a felony if committed by an adult.
That's right.
So it's applicable that it's in this section. That's what I'm trying to get at.
Back to Senator Turner Ford, it's your amendment, not the original amendment. I want to get your explanation. Are you saying to put it in both places? Or are you saying to remove it where it is in the bill and put it only in the other statute?
I believe it should be in the youth court.
Okay.
Court statute. So that would be my opinion.
That's your amendment. Did you have an amendment to the amendment, Senator Wiggins?
Yes, I do.
State your amendment to the amendment.
My amendment to the amendment is that the sections 102 through 112 in particular remain, and we simply add if is found to be a minor under the youth court, then the youth court shall apply.
So you're saying putting it in both places?
Putting it in both places, that's correct.
Okay, so the way this works procedurally, we vote on the amendment to the amendment. If it passes, that's the amendment. If it fails, we're back to the original amendment, just so we all know where we are. So questions on the amendment to the amendment, Senator Simmons?
I think it's a friendly question, Mr. Chairman. I agree with Senator Wiggins that under the youth court title, there is language, it's general language that basically says crimes by minors if committed by adults, they will be handled in youth court. So all of the crimes in 97 are crimes. It doesn't apply to, but if those crimes under 97, which this is one of them, is committed by a child, then you go to youth court. So that's the reason why I'm saying to have that language, something we're gonna, if you consider it, in to have this long 5-7 lines in the 97 title, and then put the exact same language in the youth court.
Right. Is there a question?
I guess what I'm trying to get you to withdraw your amendment to the amendment.
No, because, well, good question. No, I'm not gonna do that because if I understand what the reason for my amendment to the amendment was, the original amendment would basically take everything and put it in the Youth Court Act. But we don't have that in front of us right now. That's basically redrafting the whole bill, which is not in front of us. And by doing the amendment to the amendment, we both keep the bill here as well as put it into the Youth Court Act.
Okay, Senator McCon.
Point of order in the House, on the floor in the House. Yes, that's,
Which is,
No, and the points of order in the House typically doesn't go behind what the Senate passes to it, so I don't think that's a concern.
which is to the point of my amendment to the amendment, which is if you simply amend the bill as is and says if the offender is a minor, then the Youth Court Act shall apply, and then they go into the whole Youth Court Act, and you put it in this section.
You're saying bring the Youth Court Act section in as well to this bill?
Senator Turner Ford.
I think it needs to be referenced in the youth court law, or else the youth court judges and prosecutors may not even see it.
Right. I agree with you. Senator Hill.
if there's not gonna cause any point of order on the floor, I would support, leaving it in this section, but referencing it in the youth court statute, as Senator Wiggins has suggested.
Okay. I think we've had all of our questions. All in favor of the amendment to the amendment, please say aye.
Aye.
Any opposed, nay. The ayes have it. The ayes have it. All right. So now, any other questions on the bill as amended? It was amendment to the amendment. That becomes the amendment. Yeah. All right. All right.
House sufficient do pass as amended.
You've heard the motion is House sufficient to pass committee sub, right? Committee sub. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right. One more bill. 2563, Senator Sparks, you're recognized.
Thank you, Mr. Chairman. I'll be very brief. This bill addresses the problem we have, and you just saw we instituted a lot of fentanyl items into the schedule of narcotics. We have a lot of problems with pills being pressed showing to be a certain pharmaceutical product that are laced with substances that are killing people. What this bill does, in consultation with MBN, the Department of Public Safety, and the Board of Pharmacy, that unless you are otherwise authorized by the State Board of Pharmacy or other lawful authority, the DEA, for instance, if you have a valid purpose for it and you've already registered with the Board of Pharmacy, this doesn't apply to you. Otherwise, it's unlawful, and I want to be very clear about this. We've got a lot of lawyers in the room. It's unlawful for any person to possess, create, sell, barter, manufacture, distribute a pill press, a punch, dye plate, tableting machine, encapsulating machine, or other similar pharmaceutical producing equipment, knowing, intending, or having a reasonable cause to believe that it's used to manufacture a controlled substance or counterfeit controlled substance. This is not making the possession of a pill press within itself illegal. It is specifically when we have no authorization by a legal authority and we show intent that that is a 5-year crime. based on subsection B. In section 3, we're asking those maybe who have a health food store, who would have some viable reason to press appeal, hey, register it with Mississippi Bureau of Narcotics. Not going to cost you anything. You can just tell us, hey, I've got a pill press. If I get rid of it, I got rid of it. There's not a penalty per se for failure to register, but once again, it goes back to that intent. If I find you with a pill press, you chose not to register it, that may be one piece of the intent puzzle they prove. But that is all this bill does, and it is something we're trying to do to help MBN combat the illegal production of fake pharmaceuticals, particularly those that are laced with fentanyl. I would yield any questions, Mr. Chairman.
All right, you've heard the explanation of the bill. Questions on the bill? All right.
Not sufficient, do pass, committee sub.
You've heard the motion. All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it.
Thank you, Mr. Chairman.
all so much. Motion to rise and report. Thanks for your patience. Oh, yes. Oh, this dude. I think it's Mike Thompson, but. Do the name.